on behalf of the defendant.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last name?
So first, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest. You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gazicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay, Okay, thank you.
I have two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery, I believe.
Your Honor, I believe the date in question was around June 23rd. I have been on vacation from July 3rd until yesterday, and during that time, I had no opportunity to visit Mr. Martin at the jail. Today, I provided Mr. Martin with a redacted copy of the police report, in accordance with the discovery procedures in Wayne County, which only permit me to share redacted materials with the defendant. As for the video evidence, I currently do not have the capability to redact it for viewing or to provide a copy to Mr. Martin. With that said, Your Honor, I would like to make a motion to withdraw.
Make a motion to withdraw. I have had contact with Mr. Martin in the past and ended up with the same position I am right now. There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job, so, as he admitted, he hasn't brought me to discovery, so I just told him I'll file a motion to dismiss the case, then based on the ineffective assistance of counsel.
Okay, well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gazicki. Do you want him removed from your case?
That could further jeopardize
So as long as he's not gonna do nothing that's gonna jeopardize the case further, try to delay, like he asked me, do you wanna do German? I said, no, I'm not doing no German on the trial, I'm gonna sit in jail while I'm waiting, so I don't consent to him doing nothing that's gonna jeopardize or violate my rights.
But as
long as
he's supposed to do,
doing, what he's supposed to besides it, I have no problem with it.
Well, you understand, Mr. Martin, I've told you this previously. Attorneys it's against the court rules for them to file frivolous motions. So Mr. Gazicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gazicki to file a motion on the basis of jurisdiction.
You asked him to file a motion to dismiss today, defendant. No, I didn't. I told him I was going to file it myself. A motion to dismiss based on ineffective counsel for not providing proper representation. Judge, that's not a valid reason for dismissal. Defendant, okay, well, right now, I want to move for that. That's what this is about. Judge, motion denied. What's your next request? Defendant, this is based on my reasons. Judge, so, do you want Mr. Gazicki to... Continues. Defendant,
he cannot do that. Do you understand what I'm telling you?
The one I didn't ask him to file a motion because of no jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. That I was going to file the motion to dismiss the case because of this ineffective counsel not providing.
Okay, that's not a reason for a dismissal.
Sure.
Okay, so Mr. Martin.
I'm gonna move up. If it's right now, I'm gonna move for that. That's what we're talking about, or.
Okay, denied. What's your next one?
Based on what reasons?
Okay. So, do you want Mr. Gazicki to represent you or not? Yes or no?
Judge, do you understand that? I'm willing to adjourn this for a week so that you can obtain an attorney. Mr. Martin, why? So I can just sit in jail? No, I don't agree with that. I can represent myself. I've been studying law and practicing for 30 years. Judge, well, it hasn't been going very well for you, Mr. Martin. It might be time for you to consider getting an attorney. Mr. Martin, no, I don't agree. I've handled several cases myself. Besides, this is a simple case anyway. Judge, Mr. Martin, listen to me. I need you to understand a few things. You have the right to an attorney at public expense. We could expedite this case and get it on the docket quickly. It's a bench trial, so we might be able to schedule it later this week or next week. It would likely be next week, so that you could have legal representation. I want you to really consider that.
I don't want you to say that you don't want an attorney because you want to go to trial right now, unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel because I want to go to court right now. Do you understand that? I'm happy to adjourn this for a week so that you can have an attorney.
Why I sit in jail? No, that's why I don't agree with that. So no, I can present myself. I've been doing all 30 years studying.
Speaker. Mr. Martin, do you understand that if you choose to represent yourself at this hearing, you are held to the same standards as an attorney? Mr. Martin. No, I don't. Under Haynes v. Kerner, a U.S. Supreme Court case, pro se litigants are held to less stringent standards than those applied to formal pleadings prepared by attorneys. Speaker. Well, this isn't about formal pleadings. This is a hearing where questions are being asked. It's not the same thing. I need you to listen carefully, Mr. Martin. I'm trying to ensure your rights are protected. You've chosen to proceed without legal counsel, but I strongly urge you to consider obtaining an attorney. That said, if you continue representing yourself, you must understand. I will not permit you to question witnesses in an improper manner. You may ask questions and you may seek answers, but it must be done appropriately.
That's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute, and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present or not?
No, I don't want to delay this because there's no guarantee the next attorney may do the same thing. Just keep on not doing their job and then think they're going to delay me. So no, I'm ready to go forward. And I have.
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards.
Speaker 1, do you understand that? Speaker 2, yeah, I do my best. If something comes up or you need anything from me, just let me know. I know the basics of presenting a case, whether it's criminal or civil. Speaker 1, did you go to college for 7 years to become a lawyer? Speaker 2, not official college, no, but I studied law while I was in prison, 24 years straight. Now it's been about 30 years total, counting up to now. Speaker 1, all right. Speaker 2, that's Mr. Martin. I'm not. Look, you and I have gone back and forth in several hearings by this point. I know I'm not going to change your mind on certain. Speaker 1, right. Speaker 2, you have the right to a trial, either by jury or by judge. You previously waived your right to a jury trial, is that correct?
Something, that comes in, you let me know or whatever, but of course I know the basics of presenting a case, be it criminal or civil, so,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight.
Okay.
30 years now counting, so.
Okay.
There might be a
That's
few
your
things I might
choice.
forget.
If that's, Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on